So, thank you.
Madam Chief Justice, and may it please the Court. The reciprocal discovery order at issue in this case, unprecedented in my experience, strikes at the very heart of our system of criminal justice. The legitimacy and constitutionality of that system is predicated on a trial at which the prosecution uses its best efforts to prove the defendant's guilt, while the defendant seeks to challenge the prosecution's evidence and raise a reasonable doubt. The defendant's chief tool in that endeavor is cross-examination of the prosecution's witnesses in open court pursuant to his constitutional right of confrontation. That spontaneous, dramatic encounter before the jury enables the finder of fact to evaluate both the demeanor of those witnesses as well as the substance
Mr.
of their
Sullivan,
testimony.
nobody owns the witness. Our cases have always said they're not the Commonwealth witnesses, they're not the defendant's witnesses, they're witnesses. So if the Commonwealth gets a statement from somebody, it must turn it over. And if the defendant gets a statement from someone and wants to use it, why shouldn't it turn it over?
I think that is, yes, of course, nobody owns the witness, Your Honor, but my investigation, the fruits of my investigation, as it enables me to develop material which I want to use to cross-examine the witness, should be free from preview prior to trial.
Well, can the prosecutor be ordered to turn over a statement of a defense witness that the prosecutor intends to use to impeach the defense witness?
Well, I suppose the prosecution could be ordered to do that because the prosecution does not have a constitutional right of confrontation. The defendant does. And the right of confrontation, as it's been applied for hundreds of years, depends upon the ability of a defendant to confront a witness without having given the witness essentially a preview of what the cross-examination is going to amount to.
What case holds that?
Well, Your Honor, cases and commentators from Thomas Starkey in 1824 through Judge Young in 1998 for commentators, and cases such as federal cases such as Coy versus Iowa, cases such as Perry versus Leak, talk about the importance of the timing of cross-examination, the importance of the spontaneous encounter so that the jury gets to evaluate the demeanor of the witness as the witness is confronted with something that the witness may not be prepared, may not have a scripted answer for. Cross-examination, confrontation is supposed to be a test. As Judge Posner said in Serro, if the witness has a crib sheet, if the prosecutor and the witness can sit down before trial and figure out a scripted response to what the defendant is going to use on cross-examination, it's a meaningless test. It's basically a test where the witness and the prosecutor are able to script an answer before the test occurs. The test becomes meaningless.
I recognize that argument, and it's a valid argument, it seems to me. But on the other hand, one could argue that if the prosecution has the statement that you have that contradicts what the witness is saying, then the Commonwealth, in the interest of justice, and because this is really supposedly a truth-seeking function, that's the whole purpose, it's better off that the Commonwealth have the opportunity to investigate and see which is correct.
Well, respectfully, Your Honor, I don't think that this is all about giving the Commonwealth a chance to figure
Well, it's
out
not
how
a
to,
game.
how to,
It's
how
not
to
supposed
shape.
to be a
Well,
game.
you're right. It's not a game. And giving the Commonwealth that information, when I give the Commonwealth the impeachment material that I'm going to use to demonstrate to the jury that that witness is not a truth teller, that enables the Commonwealth to shape its case and convict my client. I should not be required, as a matter of the Fifth Amendment, Article 12, I should not be required to essentially become an arm of the prosecution so they can say, well, this witness is utterly impeachable. This witness is, we're not going to call this witness.
Sometimes the witness, if shown the statement in question, is going to testify in accordance with that statement. He told the police he saw the robber for 15 seconds. He tells the defense investigator he saw him for only 5 seconds. If he's shown both statements, he'll take the stand and say, I saw him for only 5 seconds.
Well, the witness
as Justice Cowen suggests. it might, in fact, help the witness be truthful and be consistent with the version that the defendant prefers, rather than going through this sort of artificial exercise.
Well, Your Honor, if you have a truthful witness, I suppose you're right. But if you have a witness who is lying or mistaken, this order assists that mendacious witness to perpetrate a fraud on the jury and turn the trial into a mockery.
But as Mr. Lynn points out, very frequently the witness does have access to prior statements of his or her own that are going to be inconsistent with their trial. They first tell the police that they saw nothing, knew nothing about it. They later completely change their testimony.
Fine.
Prosecutor routinely, during the witness's direct exam, addresses the witness's prior inconsistent statement, the witness's prior convictions. All of this wonderful impeachment material gets used. As far as I know, our system has not crumbled.
They have the right to do. They have the right to do that, but they don't have the right to extract it from me. That's different. That interferes with my right of confrontation, interferes with my right against self-incrimination, interferes with my right or my client's right to effective assistance of counsel. How am I supposed to know before that witness takes a stand what I'm going to use to impeach that witness? I mean, that's an impossibility. I'm basically asked to make these decisions in the dark, to decide. I mean, why do we have a rule in Massachusetts that that if I want to cross-examine a witness about a statement, I don't have to show the witness a statement first? The reason is, as people like Wigmore have said, the reason is because that's going to put the witness on notice. That's going to render the cross-examination an empty ritual, a joke. That's why you're allowed in this state under the common law, in federal court under Rule 613, and under the proposed Rule of Evidence 613 in Massachusetts.
Again, getting back to my hypothetical,
Yes,
I have
Your Honor.
not viewed the cross-examination by defense counsel of a prosecution witness who initially told the police he saw nothing, knew nothing, etc., to be a quote, empty ritual or a joke. Very effective cross-examination occurs even when the witness has seen the statement.
Sometimes yes, sometimes no. But if I have managed to obtain a statement that the witness does not know about, the value of that in front of a jury is incalculable. And every member of this Court, as a former practitioner, should understand that. That's why you have to, if you're cross-examining a witness properly, you have to set the witness up. You have to get the witness to essentially marry their prior testimony. Then you confront them with the inconsistency in front of the jury. The jury gets to see the witness squirm on the stand. All of that is wiped out if we have an order.
Let me ask you this. What's the rule in other jurisdictions?
The rule, Your Honor, in the vast majority of other jurisdictions, as we have shown in our brief, is that this kind of order is patently banned. That, in I think it's 36 jurisdictions, it is clearly banned. In federal court, it's clearly banned. There are, I think, 9 jurisdictions where it's not spoken about one way or the other, and there are either 4 or 5 jurisdictions where, as a matter of rule, it's apparently allowed, although there has not been in any of those jurisdictions, to my knowledge, any case challenging such an order on constitutional grounds. This is the first case, as far as I know, where the constitutionality of such an order, particularly under the right of confrontation, but also under the right of self-incrimination and ineffective assistance of counsel, has been raised anywhere.
Could I also ask you, Mr. Sullivan, as I understand from the Commonwealth's brief, they take the position or make the point that if that's so important to you, if that's the way you want to try the case, you still can, by accepting the mandatory discovery and not seeking the discretionary discovery. It seems to me the current rule leaves it at the defendant's option. Do you want to have sort of trial under sort of the more old-fashioned way with more limited discovery? If that's the way you want to do it,
I thought Rule 14A3B makes that impossible. I thought 14A3B says, notwithstanding the defendant's failure to file a motion, the Commonwealth may, within the time allowed, file a motion.
That's exactly right. The defendant cannot opt out of this. 14A3B says, even if, notwithstanding the defendant's failure to file a motion for discretionary discovery, even if I don't file any discovery motions, they can still come in and ask for this stuff.
Now, I understand that the constitutional interests are different in a criminal and a civil case, but as far as the value of cross-examination and the desire to get at the truth, those should be the same in both cases. And in civil cases, all the discovery is mandatory both ways, and somehow cross-examination still goes on, and supposedly the juries are able to get at the truth just as well in civil as well as criminal cases. Now, what is the difference? Why does cross-examination successful in civil cases with both sides being completely prepared with all the impeachable material, aside from the constitutional issues that I realize are different between a criminal and a civil case?
Well, I think that's a fair question. It's hard to put all the constitutional concerns aside, because one of the constitutional issues. But you've
been sitting here arguing, and your brief argues that you need the value of surprise. That's really what your argument boils down to, in essence, that and constitutional claims.
On confrontation, yes.
Right. So I'm saying you don't have that in civil, yet civil trials are a search for the truth, and they seem to succeed. And you don't hear people saying, well, we can't cross-examine because we've given over all the impeachable material.
Civil trials are a very different animal with a very different burden of proof.
I'm not at all sure that you would necessarily get this in civil discovery.
I don't know, Your Honor.
In other words, the work product doctrine, you may get documents that were in the possession at the time. You may get, there's a huge amount of information that you would not get in the civil trial that is in.
You could force this to be disclosed by an interrogatory if you couldn't get the document, though, on a civil
Your Honor, I think you would have to make, at least under Rule 26, and I'm not a civil expert, I think you'd have to make a special showing. They've made no special showing of need here. They haven't said.
You get it in an interrogatory. You wouldn't necessarily get the document. You get it by asking the appropriate interrogatory.
You might or might not.
Well, I would say, number one, that there are many provisions I know about in the civil rules where they have to make some kind of a special showing. And there's no special showing made here. In any event, it's a totally different animal.
It's different in this sense, is that you wouldn't get, you might ask an interrogatory, but if you ask, it depends what the interrogatory is. But if, for example, you went, I'm taking the example that one of the amicus briefs, the point here is not to talk about civil discovery, but if you went and obtained documents from a third party that you simply had decided to go and investigate for whatever reason, because you got a hint, that this person has put in a claim for working and that they were in fact working overnight, you would not necessarily have to disclose that. If there was an interrogatory, please identify any documents that are inconsistent with your defense or which may show up on. No civil judge would enter such a
please identify all of the documents you're planning to use on cross-examination at trial. I don't think that would be turned over in a civil case. And certainly, in a criminal case, not only do you have the different burden of proof, not only do you have the right of confrontation, you have the right against self-incrimination. Article 12 says that a defendant may not be compelled to furnish evidence against himself. And that's been interpreted broadly by this Court, going back to Emery's case in 1897.
Well,
I'm not supposed to have to give them a roadmap to how to convict me. That's what this order does.
No. The right of self-incrimination means words out of his mouth or her mouth. And then if you've got something like that and it's arguably subject to the disclosure that we're talking about today, you go back to the judge and point that out. And then the order's changed, it's redacted, it's whatever, protective order is put on it, it's impounded, you name it. But the mere fact you're going to, impeach witness X, not the defendant, with some material, I don't see how that implicates at all his right of self-incrimination.
Witness X's statement, not the defendant.
Well,
that's right.
Because I am my client's agent, and it's a representation by me that I have this statement. I went out and got this statement. I think the statement is really important, and I'm going to use the statement at trial. Yeah. All of that is essentially, and it's an implied statement by my client. It's a statement by me. This is what I'm going to use.
How is that different from being required to disclose the statements of the witnesses you intend to call, or the witnesses who you or an alibi defense, for example? How is it different?
It's completely different, Your Honor. In all the cases, such as Pasco, this Court's case, and the federal cases they rely on, Nobles and Williams, are all about that, are all about statements of defense of witnesses.
The code word is case in chief.
Sorry,
it's case in chief. It's the defendant putting on the case in chief.
If I'm going to present evidence, if I'm going to present witnesses, it is fair for me to have to turn over statements of those witnesses. I'm not being compelled to produce those witnesses.
Along those lines, could I ask you, one of the things that sort of puzzled me about the premise of these briefs I didn't want to get to. Everybody talks as if all this order is about is impeachment of prosecution witnesses by prior inconsistent statements. What about the situation, in fact, a very common situation, where a defendant intends to elicit affirmative, substantive evidence out of one of the Commonwealth's witnesses? Example, a Commonwealth witness that places the defendant at the scene of the murder, blah, 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 obviously highly incriminating. Commonwealth calls him, is going to put him on as a Commonwealth witness. But through defense investigation, the defense has learned that this same witness has a lot of information about the defendant's intoxication, how much he drank, the signs of horrific intoxication, that he intends to affirmatively present, as part of raising that line of defense. He's not impeaching him. In fact, he wants the jury to believe him when he talks about how drunk the defendant was. Not impeaching him at all, using it affirmatively. But it's not the defendant's case in chief. Do you have a problem with the idea that that kind of statement should be turned over to the prosecution so the prosecution knows what affirmative evidence you intend to elicit? The fact that it's going to happen on cross-examination is still affirmative evidence.
It's a little bit different, Your Honor. I agree with you, but it's their witness. They've chosen to call that witness. They should not be put on notice that maybe we shouldn't call witness A. Let's call witness B instead, because witness B isn't going to produce that evidence for the defense.
You're saying you get to put in affirmative, not just impeachment and confrontation and all of this. You're saying you get to put in affirmative evidence by ambush?
It's not by ambush, Your Honor. It is based on my own work product, my own investigation. Rule 14 does not provide for discovery of statements by prosecution of witnesses. The reporter's notes make that clear in 2004. This Court's recent modification of the rule in 2005 limits disclosure of statements to statements which the defendant intends to present at trial. And this Court, if this Court allows this order to happen, this is going to affect a sea change, and a sea change for the worst. It will tilt the balance dramatically in favor of prosecutors. It will eviscerate the constitutional balance that's existed here for hundreds of years. I ask the Court.
Mr. Sultan, before you conclude, I know your light is flashing, but it strikes me that Justice Sussman's example points up the practical problem that you were noting in your brief, and that is this affirmative statement or this statement that would contain things that you hope the witness would testify to. I assume you wouldn't be planning on using that statement unless the witness, in fact, testified differently.
Of course, and I don't know that until
the witness testifies.
That's part of the problem with this kind of an order, Your Honor. Thank you very much.
Thank you, Mr. Sultan. Mr. Lynn?
Good morning, Your Honors. There are countless situations in which a prosecution witness will have extensive pre-knowledge of the defense cross-examination material. A trial after a mistrial, for example, a trial after a reversal on appeal, a trial after an extensive pretrial hearing, and, of course, situations where the witness simply remembers the statements that he's made previously, or where the prosecution discovers them on their own and presents them to the witness before trial. In none of those situations is the defendant's right to cross-examination impinged upon in any way, let alone violated, even though the result at trial is precisely the same. The witness is prepared to answer the defendant's question. And therefore, the order in this case simply cannot violate the defendant's rights. And in any event, the defendant still has extensive cross-examination ammunition. If there is an inconsistent statement, the statement is nonetheless inconsistent.
Mr. Lynn,
yes.
I don't wish to take you off on this point, but one of the things that occurs to me is that if, by effective cross-examination, by surprise, a defendant has been acquitted, jury doesn't believe the testimony of the lead witness, let's assume there are only two witnesses, simple case, you wouldn't see that on appeal. And the difficulty I have with your hypothetical, which is a fair hypothetical, not every case turns on effective cross-examination, but I can only assume that in a case where the opportunity to seriously undermine the credibility, which is essentially what cross-examination is, didn't have such an impact on the defendant, on the jury, because the jury in your hypothetical would have convicted the defendant. Are you with me?
Well, I understand entirely, right? But if the jury
so you have to take out of your hypothetical all those cases where effective cross-examination led to acquittal. You are only left with cases where effective cross-examination led to a conviction.
Absolutely. But that's
so that you can't test you can't test that to me is not helpful. There may be other reasons that are helpful, but that's not the most helpful one. Because there are lots of cases that don't turn on effective cross-examination. They may turn on, evidentiary rulings or jury instructions when there was no surprise at all.
Absolutely, Your Honor. The question isn't the result. The question is whether the defendant had a right whether this order will leave the defendant with a right to effective cross-examination. And the answer is it has to, because otherwise, if a witness's foreknowledge violates the defendant's right to cross-examination, then it violates the defendant's right to cross-examination. In every situation, we could never have a retrial after a reversal on appeal or after a mistrial or anything, because the witness now knows what's coming and can address it.
Have you found any case anywhere in the United States that defines the right of confrontation as anything other than the right of the defendant to examine the person, cross-examine him, in open court in front of the jury?
I can't think of one off the top of my head. I mean, certainly there are cases that say that if the judge affirmatively limits the defendant's cross-examination material, that, of course, is an impingement on the defendant's right to cross-examine. But I know of no case.
So when you use the term, quote, effective cross-examination, effective has to be defined in those terms. It doesn't necessarily have to be defined in terms of cross-examination. It has to be a complete surprise. That's what they teach in trial methods classes. But that has nothing to do with what the constitutional obligation might be here.
That is certainly the Commonwealth's position.
But doesn't the defendant cite a case from the Seventh Circuit, I think, Judge Posner, where the judge says that?
The judge does say that. The Commonwealth's position, with all respect to Judge Posner, is that's an offhand statement. It's a single sentence. The ruling in Cerro is that this is not allowed by the federal rules of criminal procedure, which the Commonwealth fully concedes.
Could I ask you, Mr. Leno, setting aside sort of constitutional issues, I ask sort of some pragmatic ones. Impeachment material, by definition, is used by prior inconsistent statement, is something that turns out to be inconsistent with the witness's trial testimony. I have some sympathy for Mr. Sultan's position that until you've heard the witness testify at trial, you don't know whether what you hold in your hands has any value as a prior inconsistent statement. You can't make a selection in advance about prior inconsistent statements because the witness might testify consistently with what you hold in your hand, might even testify better for your side than what you hold in your hand, and the last thing you'd want to do is raise it. How can a lawyer tell in advance, this is going to be a prior inconsistent statement that I'm going to use at trial?
Well, this is what the Commonwealth discusses in the Chappie section of its brief. That is certainly a practical concern here. But there has been such extensive discovery in this case. The defendant has a very good idea by this point what our witnesses are going to say. If there's any question as to what witnesses we're going to call, this order absolutely requires us, before the order even takes effect, to provide a limited list of the witnesses that we affirmatively, in good faith, expect to call, not this whole universe of witnesses that we might call if things come up. So first he's going to have this list of witnesses that we genuinely expect to call at trial. It only applies by the stipulation of the parties to witnesses whom we have provided prior statements to through the discovery process. Under those circumstances, the Commonwealth's position is the defendant should have a pretty good idea of what the witnesses are going to testify and what inconsistent statements he's going to use.
And if those witnesses for whom you provided statements to the defendant, if they change their statements in interviews with you, aren't you under a duty to inform the defendant?
Absolutely,
so
100%.
That the defendant would know if the testimony is going to change. The only situation that might be encompassed by Justice Osmond's question, it seems to me, would be when the witness, to your surprise, to everybody's surprise, changes his or her testimony.
And I would point out, even in Reynolds, this court emphasized, in Reynolds the judge found that the defendant had withheld the statements in question in bad faith with the intent to surprise. And even in those circumstances, this court said the judge has to do the Chappie analysis, and exclusion of the statement should be a last resort. So especially if something comes up that no one's expecting, if a witness says something that nobody could have expected, and he happens to have a statement that's inconsistent with that, it would be a clear violation of the defendant's right to compulsory process for the judge to exclude that statement.
Mr. Lynn, in this case, there is a reciprocal discovery order in place which requires the defendant to provide you with statements of witnesses he intends to call.
Yes.
In his case, is that right?
That's correct.
Has that been done, or is that to take effect just before the trial?
Repeat.
Has the defendant provided you with a list of his witnesses?
I am not. I believe there's still open discovery in this case. I believe that there's the last time that there's a hearing that's been transcribed, and that was, albeit back in April. There was still Mr. Sultan was still making a claim.
Because he hasn't objected to that part of the order, that
Correct.
he will provide you
yes.
with a list of his witnesses and statements of those witnesses.
Absolutely. That's not an issue. The part of the order that says that the standard stuff that he has to disclose, the witnesses he plans to call, if he intends, my understanding is he doesn't plan to raise an alibi defense in this case, but if he would certainly be required to reveal that to the Commonwealth under the rule. That's not an issue
I
here.
assume once you get that list, the Commonwealth will go out and sort of quickly conduct investigations
Absolutely.
of these witnesses.
And
I
I think
assume you will turn over would you view it your obligation to turn over any
Absolutely.
inconsistent
Ongoing
statements?
obligation to provide any information that's covered by these discovery orders.
Well, no. But how is that information covered? So let's assume you gather statements of the defendant's witnesses,
Right.
maybe that he made to other people or whatever the format is, that are inconsistent with what the defendant asserts those witnesses will testify to at trial. So those witnesses maybe will testify to a trial the defendant wasn't at the scene, but you now have a statement the witness made to someone else that, in fact, he saw him there. So there's no order at the moment that would require you to turn that over to defendant. Oh, by the way, we got a statement from a witness you intend to call that is inconsistent with what he's going to testify to. I think that there's no order in place right now that would require that kind of reciprocal discovery.
Well, that's not reciprocal discovery. That's the Commonwealth's burden of discovery to the defense. I'm not entirely sure what the scope of the previous orders that the Commonwealth has been.
I didn't see any order that you were required to turn over to the defendant any witnesses, any statements that you might have of his witnesses.
Right. But I would point out that I believe the case law is clear. Wardius versus Oregon leaps to mind that if we are going to get impeachment material impeachment material that he intends to use to impeach our witnesses, we are required by the Due Process Clause to reciprocate, to give any statements that we intend to use to impeach his witnesses.
What case is that?
It has to be in kind.
What case?
Wardius versus Oregon.
If we follow his line of reasoning, might we not also be throwing into doubt those provisions of the criminal rules that say, for example, a defendant has to disclose alibi witnesses?
Absolutely.
Because he could argue legitimately there, if I disclose that, I'm giving up part of my right to confront the Commonwealth witnesses with complete surprise that I've got these other people that are going to say I wasn't there. It also impinges on my effective right of representation. The same constitutional arguments could be made as to that, as to mental responsibility, as perhaps to a dozen other items in the rules, and they all come tumbling down. Doesn't
Absolutely.
that show the fallacy in this whole thing?
Absolutely, Your Honor. And that's the argument the Commonwealth makes regarding the self-incrimination argument that my brother raises. The disclosure of alibi or the witnesses that the defense is likely to call at trial is much more indicative of the defendant's thought process. It's almost certainly going to be the defendant telling his attorney, I was at Joe's Bar and Grill at the time of the crime, so I couldn't have done this. And it's certainly going to be him say, my friends, Jim and Bob were at that bar, and they can testify on behalf of that.
And
It's less likely with impeachment evidence that it's going to be coming from the defendant. It's much more likely that it's going to be coming from the
that could
investigator.
seriously damage the defendant's case, because the minute you find out he's going to call those people, you start loading up against them.
That's absolutely the
That they got records of
purpose.
convictions, that they were drunk that night, that they were seen a mile away when they supposedly were watching the football game with the defendant and all that kind of stuff.
It is absolutely the purpose of the alibi disclosure rule to allow us to destroy the defendant's alibi if it's not reliable.
If this order were not in place, once you got the defendant's list of witnesses and statements, if you got them, would you, and you went out and investigated them and got contrary assertions from those, if the statements were not in writing, would you have to give them over to the defendant?
You mean,
Usually, isn't it writing or reduced to writing?
It's reduced to writing.
It would have to meet.
So if they were oral, if they were just given to a state trooper orally, and the state trooper's going to get on the stand and testify, Jane Doe told me the opposite of what she testified to, you wouldn't have to turn them over in advance.
Well, both the order at issue here and any reciprocal discovery that we're required to produce under Wardius versus Oregon is limited to the definition in 14D.
Written,
so
correct.
He's not required to give us statements that
Right.
don't qualify under 14D, and of course we're not
Right.
responsible. I mean, unless they're
Right.
like
So
they're exculpatory or something.
What
like
I'm
that.
getting at is if we rule in your favor in this case, aren't we probably going to see many fewer, if there even are any, a reduced number of written statements from investigators? They'll be oral now, and the investigator will just get up and testify that this is what she told me, or the defendant will be forced to cross-examine without a written statement.
That's possible. It may be that the defense bar will consider it more valuable to actually have these statements, a record of these statements that they can study, than the risk of
Is that
turning them
really
over to
going
the
to happen,
Commonwealth.
though? Because your people are going to want to nail these statements down, and if
No,
you've
no,
got
I
it in
didn't say,
writing...
I didn't say the Commonwealth. I said we're likely to see defense investigators
Right.
just take
It's
oral
investigators.
statements rather than written.
Well,
Right.
that
There's
could
a
be.
question as to whether the defense bar will see it more advantageous to have records of these statements, or whether they will risk forgetting them in order to thwart discovery.
Mr. Lane, putting aside the constitutional arguments, let's assume for the moment we agree with you. Doesn't this really come down to how we interpret our own rule?
It
I
does.
mean, the rule's not quite crystal clear on this, or at least on how this kind of problem should be managed.
I would argue that it is reasonably clear. Certainly in Reynolds, looking at the pretrial conference report, this court said any witnesses means any witnesses, and so that was crystal clear. Here, the Rule 14A3A says any evidence discoverable under Rule A2, and Rule A2 says any statements of persons. So that's even broader. So I think it's
then has
certainly
that, has that mysterious clause at the end that seems to be not really necessary if, in fact...
14A3?
Right.
Yeah, I mean, certainly our
3A.
position on the last clause of 14A3A is that it says exactly what it means. It includes this very common type of evidence, but it's certainly not limited.
But that statement wouldn't have to be there, of course.
Absolutely not.
It's duplicative. So,
Yeah, we
so
clearly-
it creates, well, my whole point is it creates a little bit of ambiguity about what we really intended here. And did we really intend this? I mean, we promulgated these rules, so in
That's
part,
true.
there's a legislative intent issue.
But I think the language of the rule authorized the judge to do this. I think there's no question here as the issue of whether she exercised her discretion properly isn't even before the court. That was conceded below by the defendant. But the question is whether the language of the rule as it stood in 2000 when the defendant was indicted authorized this. And the Commonwealth's position is any statements of persons means statements of persons, including the Commonwealth's witnesses. If there are no further questions, we'll rest
thank
on our
you,
brief.
Mr. Lynn.